Okay, we want to call to order the Tennessee Auctioneer Commission on Monday, August 1st, 2016. Do we get a roll call?
Ronald Collier,
Here.
Bobby Colson, here. James Phillips, here. Jeff Morris,
Here.
Adam Lewis.
Here.
All accounted for and present.
Good.
Thank you.
Get a notice of the meeting.
Today is Monday, August the 1st. This is the Auctioneers Commission, and the notice for the agenda was posted on July the 27th on the website. It is now 9:01. We are getting started with the Auctioneers Commission meeting. Thank you.
The agenda, we need to review and adopt the last meeting agenda. Is that right?
I move that we adopt the agenda as written.
Second.
Motion's been made to adopt the May meeting and second. All in favor say aye.
Aye.
Okay, got a election of the officers.
Well, we gotta go through the minutes. The minutes next.
Minutes from May 2nd, if we could approve them.
Hear a motion to approve those in May.
So moved.
Second.
Moved and second. All in favor aye.
Aye.
Election of officers to hear any nominations.
I'd like to nominate Howard.
Motion's been made.
He ain't got but one more year left.
Motion's been made to make Howard Phillips chairman. Jeff Morris is vice chairman.
Second.
Motion's been made and second. All in favor aye.
Aye.
Aye. Do I turn it over to the new chairman now? No. Good one. Okay. Got an education request and approval.
Probably in your
What do we
tab.
have to
It's
approve?
on your tablet,
Yeah.
Mr. Howard, on page 7?
Page 7,
Nashville Auction School.
Correct.
Nashville Auction School.
Is there anybody here to present that? Okay.
Just the application.
Read it and. No, the courses themselves. One from Tammy Miller and the one from Robin Treadway.
Discussion on them. 7,
7,
page
8,
7.
9.
7, 8, 9.
Just give us a second, Mr. Chairman. Let's look and see what they're proposing here. Second.
Motion's been made to approve the continuing education seminars and second. All in favor aye.
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 Chairman, if I could interrupt for a second. We've got a formal hearing today. If it is okay with you and the board, we would like to kind of reschedule because we've got attorneys and the judge here to fit them next and then continue on the director's report and applications at the end of the meeting. Is that okay?
Aye.
Fantastic. Okay. So I will turn it over to Robin for you to decide the order.
Okay, well, the first thing is we have a representation. I'm going to turn off to Mr. Gregory.
Morning, Dennis Gregory, one of the litigators here with the agency. Previously, in the matter of Macklemore Auction Company, LLC, and the owner, proprietor of that company is here, Mr. Macklemore, along with his attorney, Ms. Gentry. Parties have come to a proposed agreed, what would be a proposed agreed final order. Not sure if we can distribute some copies around. I hope I have enough for everybody. This is going to be an unsigned version. originally came before the commission several months ago. Just kind of summarize what the facts were. There was a complaint that was opened up after another individual had contacted the agency regarding the respondent's website with the information about paying referrals to individuals for auction leads. And of course, based on not the statute, but the rule 160-01-02 unlawful rebates, since there was no mention that the individual would have to be a licensed auctioneer, that the website was actually violating the rule. Originally, a consent order was approved by the board, again, some time ago, recommending a civil penalty of $500. Today, what is being proposed is the final order will reflect essentially all the terms of the original consent order, with the exception that the respondent would pay a civil penalty of $200, and of course the discipline would still be there, history of discipline would still be there, recorded on the DAR, but in effect, what you see before you is what was in the consent order, with the exception of the difference in the amount.
Who changed the amount?
That was just a simply agreed on between the parties.
Between
Mr. McLemore's attorney and myself. And if you'd like to hear from Ms. Gentry, or the respondent, I'm not sure statement or not.
I don't have any particular statement prepared, but following the meeting last time, when this was scheduled in May, we spoke with the attorney at that time.
Mr. Adrian Chick at that time.
Yes, and that was the amount that he suggested, and we agreed to that as an attempt to.
One piece of mitigating, it's a mitigating factor, is that the website posting came down relatively soon after the complaint was opened, and to our knowledge, there were no referrals paid. So that's to the extent that it's mitigating. That's what led us to the $200 civil penalty.
The other issue that I think is significant here is that the website was directed only to timed internet sales, and that is something that is not regulated by this statute or this board. Mr. McLemore has not done live auctions or simulcast auctions since May of 2011. So there was no attempt to be confusing to anyone, because he did not conduct any business generated from that website that was overseen by this board.
One more question.
Sure.
Did the auctioneer commission set the penalty as $1,000? Is that where that came from?
No, the auctioneer commission set it at $500.
Oh, at $500.
At least that's what's recorded in the consent order, which tells me, although I wasn't here for the original meeting back when the consent order was approved, that 500 was the agreed upon amount. Guess we'd have to look at a legal report to know exactly what the amount was, but I can only assume it was 500.
You could give me a second. Could we get your full name for the record,
Oh,
please?
yes, my name is Martha Gentry. I'm the attorney for McLemore Auction.
Thank you so much.
Morning, Commission members. I was the attorney that first had this case in litigation. Then I went on leave for a while, and Mr. Gregory took over. But I believe the complaint first alleged that he was giving rebates to live auctions, and I did a lot of research on that. I even went back to the Internet Archive, the Wayback Machine, and looked at the previous advertisements that have been done, and and I spoke with the attorney some, and I was satisfied that he had not, in fact, given unlawful rebates. The only thing that I saw that was an error was that from reading, if someone who wasn't familiar with his business read the website, it could look like they were saying that they would pay it to all kinds of auctions. But in fact, I was convinced that that was not the case. And I had extended an offer to the attorney at the time that if he would correct his website, then I would ask the commission to just dismiss it. And I can testify that he did, in fact, change that website completely. And I don't believe there's any problems in his current website. So he's certainly done everything to try to comply, and he is in compliance as far as I can tell now. Thanks.
I move that we accept the agreed final order as drafted in front of us, and that we approve it.
Motion's been made to adopt the request. Second.
Hold on. I still am not clear on this. We had a website that said, basically, call us, we'll give you a referral fee for us to do an auction. Is that not correct? Is that not what the website said?
I'd like to see a copy of what was at the time on the internet, the posting.
Yeah. See it. Looks pretty much to me like, like he's paying out a pretty good sum for referrals. You guys, motion still out there to reduce it?
Mr. Gregory, that's the part that you said was taken down pretty quickly? Yes. Okay. Oh, like, it hadn't been up there for some time now? Okay.
You need, press this, thank
I'm
you, so
sorry.
you can be on the record. Thank you.
Yes, Martha Gentry for Macklemore Auctions. Despite the fact that the language on the website said auction, the business was not engaged in live auctions or simulcast. It was a timed sale. When the potential confusion for that language was brought to his attention, it was removed and it has been clarified. But the fact is that no rebate or referral fee was ever paid.
My understanding that Mr. McLemore basically operates a bidding platform, is that correct?
Excuse me?
A bidding platform is for fixed time auctions, is the way I understand his business. Okay.
And members, if you look at the bottom of the website page that was that I think Mr. Chick. September 25th, 2014 is where he went back to. So we're talking about almost 2 years ago. So
Right.
This was just to give you an idea about the time frame.
Chairman, I just restate my motion that it's being the same as before, is that we accept the proposed agreed final order as written.
Second.
Motion's been made to accept. Second. All in favor say aye.
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 No.
I'm going to recuse myself.
I'm gonna say no.
Go ahead and for the record, do a roll call. Motion has been put on the table to accept the change in the presentation. The motion was presented by Mr. Jeff Morris. We will do roll to make sure that we've got everybody accounted for. Ron Collier? Your vote, I'm sorry.
No. I thought you, no.
No? Mr. Bobby Colson? Recusal, thank you. Mr. James Phillips? Jeff Morris?
Aye.
And Mr. Adam Lewis?
Aye.
Okay. We have 2 yeses, 1 recusal, and 2 noes. So the motion has failed. We have 2 yeses, 2 noes, and 1 recusal.
And just as of just recently, Mr. McLemore has agreed to the original terms in the consent order. So effectively, the agreed final order where it says 200, the language could be stricken, or we can do a new one with a $500 civil penalty. If those terms are acceptable.
That's the original.
Originally asked Keeling to put on there.
Motion to accept it with the original. Is that what we're gonna do?
I move that we accept the final order with the change from $200 to $500 in the final settlement.
Motion been made to accept the change. Here, second.
Second.
Second. All in favor, aye.
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 Thank you. Okay. Thank you, Dennis.
I also have one more thing to present. I understand it's on your iPads. I can't tell you where.
Page 22 on your iPads.
This is a representation of a matter that was originally heard in January of 2015 concerning what appeared to be unlicensed activity from a motor vehicle dealership, as they had requested that persons turn in a signed document saying how much money they would pay for a car. The recommendation at that time was for a consent order of $500. The decision was $1,000 and a cease and desist. It was represented in August of 2015 because it was a referral from Consumer Affairs. The investigation in March following the January decision stated the intent was to collect those silent bids. And again, no sale ever took place, there was no auction, and nothing was ever negotiated. Again, it was represented, and it was a companion case with the motor vehicle case, but the original decision was by you all to continue with the $1,000 civil penalty. Since then, I will tell you that this particular dealership is closed because there was a companion case with the dealership. They paid a civil penalty in the companionship with the dealership. The party in question is no longer in operation, and therefore there is no respondent at this point in time. Therefore, I'm asking permission to close this matter as there is no person to go after.
Make a motion, we accept council's recommendation.
Second.
Motion been made and second. All in favor, aye?
Aye.
Aye.
Thank you.
Address, probably take about 10 minutes, a case that I'm going to ask the commission to close.
Oh, go ahead. You have a problem with that, Ms. Ryan?
No, that's fine.
Okay, go ahead, Adrian.
I haven't heard it. That's okay, Adrian. Go ahead.
Go ahead.
Good morning, commission members. Adrian Chick. Commissioner Phillips and Colson will remember this case, but the rest of you might not be familiar with it. Back in 2012, we had about 38 complaints filed against an individual named John Vince Trotter, and he did business as My Auction Connection. And the basis of the allegations were that he had contacted people all across the United States, mostly motorsport dealers selling things such as jet skis, boats, camper trailers, and that he had led them to believe that there was going to be a reserve on the auction, but in fact there was not. So people lost a lot of money because he sold these things well below what the dealer thought was the reserve, and we filed charges on him, and we had about 15 witnesses that we actually flew in from all across the United States, had a hotel to put them up in, and the night before the hearing there was a conference call with the judge and opposing counsel, and a motion was made to dismiss because I didn't intend to present expert testimony. Well, the judge dismissed the case. I brought this back before the commission, and the commission voted unanimously to set aside that order because the commission and the department did not believe that an expert was necessary for allegations about misrepresentation and fraud. And that case, but there was a provision in the order that said that the commission actually could not review that it could only be done in Chancery Court. We disagreed with that. We thought the commission's order to set aside was valid, but we filed a petition for judicial review in Chancery Court just as a precautionary measure. And the respondent, Mr. Trotter, filed a petition for judicial review as well. So that sat up there for several years. In the meantime, Mr. Vince Trotter filed for bankruptcy. There was a hearing in Nashville where the federal district court found that he was, bankruptcy court found that he had committed misrepresentation and fraud. He was later arrested in Michigan, I believe, for similar charges, and he did some time up there, and he's still on probation and can't leave the state. During this time, his auctioneer license also expired. It's well past the point of renewal. So I'm asking at this point that the commission agree to close these cases because there's simply it's almost become moot. The respondent is gone. He's unlicensed. He's serving still on probation. So my motion is that we close all these old complaints against Mr. Trotter and flag him. If for some reason he were to ever come back and apply for licensure, there's more than enough grounds. The finding of fraud, the conviction in Michigan, there's more than enough grounds to deny a license if he should ever apply. So that's my request.
Chick, if I could also clarify, this is what we emailed the commission on for their opinion over a week ago. I sent an email to everyone to let you know that that was your opinion and all of legal counsel's, correct?
Right. Well, I believe that was asking the commission if they wanted to appeal it. We reckon even the Attorney General, we all agreed that there's case law from the Court of Appeals that even says you don't need an expert for misrepresentation, but there's really no point in appealing, and it's just kind of become moot. So now I'm asking that the commission close those cases. And there were a few more that trickled in after that weren't received in time for the notice of charges.
Thank you.
It was very disheartening when I read that.
Your microphone. Thank you.
I usually talk so loud, don't make no difference. It was very disheartening when I read that order. But I don't know, I guess we're at this point, we're spending good money after bad. What do you think, Howard? You were here. I mean, just so long as you, like you said, you flag it, just so everybody knows if something was to, which I don't think we'll ever see him again, but you don't ever know.
It'll
Best,
definitely
best
be
thing
flagged.
for the state of Tennessee is if he never returns. So
Michigan can have him.
I'll make a motion, we accept council's recommendation to dismiss, is that it?
Well, just to close, flag and
Okay,
close.
to close.
Second.
Motion's been made, second, closed. All in favor, aye?
Aye.
Aye.
And I'd also like to just point out that even though it happened in a roundabout way, the commission did do a job of protecting the citizens by he left the state. So I think the commission, although it took forever, did achieve its purpose. So thank you.
But removes about 38 cases off of our case log, and
Yes, sir.
that's-
That too.
Continue the formal.
Thank you. We will continue now with the formal. Yes, Robin's getting all ready.
Oh, I'm good. Put your hairnet on, Bobby. Bobby, put your hairnet on if you're gonna be a server.
Go ahead. Just go ahead and pass it out. Those findings. I'll tell you what, just, yeah, okay. Pull them back and get the notice. Yeah, yeah.
I'm sorry.
That's all right. Really?
We're doing now.
Here's the court reporter. Thanks. Yeah, that's it.
All right. We are ready to proceed now. I would ask at this time if there's any in the audience, if there's any, if Mr. Tony Reed or any representative for Mr. Reed is present. All right. Seeing none. Members of the commission, this is a hearing before the Tennessee Auctioneer Commission to consider the matter of Tony Reed doing business as M&R Auction Company as a result of the notice of hearing and charges filed in this matter that has been passed to the commission members for their review. That notice was filed by the Department of Commerce and Insurance on February the 18th of 2016. My name is Tom Stovall, and I have been assigned by the Secretary of State to be the administrative judge at this hearing. As the administrative judge, I will make all rulings of evidence, law, and procedure under the authority granted me by the Tennessee Administrative Procedures Act. However, I will not participate in the decision that is made on the merits of this case. That decision will be made by the members of the commission that are present and participating in this hearing this morning. Would all the members of the commission please identify themselves for the record?
Ronnie Collier, Mr. Chairman.
James Phillips.
Bobby Colson.
Adam Lewis.
Jeff Morris.
Thank you. Members of the commission are instructed that their decision in this matter must be based only upon the record that's produced during the course of this proceeding today. Failure to abide by this instruction could result in the matter being reversed or remanded back to the commission should it be appealed to Chancery Court. I will, for the record, Ms. Robin Ryan, attorney with the Department of Commerce and Insurance, represents the department in this matter. Mr. Reed is not present, nor is an attorney present on his behalf. And Ms. Ryan, I understand, based upon a conversation that I had with you prior to going on the record, that you intend to move for a default in this matter.
I do indeed, Your Honor.
And do you have proof that Mr. Reed has received notice of this proceeding?
I have, Your Honor. This matter was sent via both certified and regular mail. The certified mail was returned on 3/16, but regular mail was not returned. Certified mail was returned, not claimed. We sent a witness and exhibit list on July 22nd, and that has not been returned. The notice of hearing was also sent to the email address we have, and that was sent on March 18th and was read. We've got confirmation of having been read on March 19th. After filing, I was contacted by attorney Dan Boyd, who stated he represented Mr. Reed in his pursuit for Social Security disability and would be representing him in this matter. However, on June 28th, I spoke with him again, and Mr. Boyd said he was not going to be representing him here today, but that his client, Mr. Reed, had read the notice of hearing and knew the hearing was set today, August 1st. He suggested I send a payment plan, which I did again, and that's not been returned. Therefore, based on all of this, I ask that we be granted a default judgment and be allowed to pursue this matter.
Members of the commission, it appearing that Mr. Reed has received notice of this hearing, I will turn it over to the commission to determine whether or not they wish to grant the motion to hold him in default and allow the state to proceed with its case, or whether or not you wish to deny that motion and continue the matter to the next setting of the commission and re-notify Mr. Reed to see whether or not he would appear at another setting. So I'll turn it over to the chair to decide this issue. Members of the commission.
No, I think we accept the default judgment.
So what is your recommendation, or what is it you're asking for?
I'm asking to be allowed to proceed today because we state that we would show and we assert that he has had sufficient notice of the hearing today and that he is just choosing not to be here.
You need a motion, is that what we need?
Yes. The issue as to whether or not the respondent, Mr. Reed, has received notice of the hearing is a legal determination, and I have made that determination, and the determination is he's received notice. The issue of whether or not to grant a default is a discretionary decision that is to be made by the commission. So it's your decision to decide whether or not to hold him in default and allow Ms. Ryan to proceed with her case, or to deny the motion and continue the hearing until the next sitting of the commission.
Chairman, I move that we accept the default judgment and proceed on. I think notice of hearing has been made, and that he had all the rights and privileges of being here today, but he's not. But I think that we'll allow the state to continue this case.
Motion's been made to allow. Here, second.
Second.
All in favor, aye?
Aye.
Aye.
All right, very good. Mr. Reed is held in default. Members of the commission, before I allow for opening statements, I will ask if, now that the commission members have had an opportunity to review these charges, if any of the commissioners have received any prior knowledge about this matter or have received any ex parte communications concerning this case, and if so, put that on the record. Seeing none. Once the commissioners have reviewed this document, I will allow Ms. Ryan to proceed with her opening statement. All right, it looks like we're ready to go. Ms. Ryan, go ahead.
Thank you. The matter before you today is a question of unlicensed practice as an auctioneer. You will learn that M&R Auctions was in business for about a year prior to an investigation, and that business was auctioning off property owned by Tony Reed, who is the person who owns M&R Auction. M&R Auction is not a corporation or a partnership. It was operated at that point by auctioning off property that we learned in an investigation was owned by Mr. Reed. You will learn that after Mr. Reed received a call from one of our investigators in December in 2014, he closed the business. You will learn that a subsequent investigation, he admitted to selling the items he owned, and that he was not aware he had to have a license to auction off the property, and that is the reason he closed the business after the phone call. You will hear that M&R Auction is not in business today, and apparently has not been in business since December 2014, but that Mr. Reed would not or could not pay the civil penalty issued to him in a consent order. It's this state's position that his actions as an auctioneer selling items through his business required a license under 62-19-102 because Mr. Reed's property could not be advertised or auctioned by his business, M&R Auction. There was no exception to this requirement for a license. You will learn, or you have already heard, that he had an attorney representing him as he was applying for Social Security disability. And I will tell you that if indeed he is granted Social Security disability, a civil judgment would be protected and not be able to be collectible from those monies. But at the end of this hearing, I'm asking that you find this respondent in violation of these laws, that you issue a civil penalty and assess the court costs against this respondent.
Thank you, Ms. Ryan. I'll call your first witness.
I call Roxana Gumuccio.
Want me to sit at this side? Yeah, let me get my. Your Honor.
Raise your right hand, please, ma'am.
Do you swear or affirm the testimony you're about to give will be the whole truth and nothing but?
I do.
Could you please state your full name for the court
Roxana Gumuccio.
and your position with the state of Tennessee?
I'm the the executive director for the Auctioneer Commission right now.
And are you considered the acting director?
Yes, I am.
And how long have you held that position?
For 2 weeks.
And have you had other positions as an executive director with the state of Tennessee?
I have. I am the executive director for the State Board of Cosmetology and Barber Examiners, and I've been with that board for over 3 years.
So you understand the process and you understand the obligations and responsibilities of the executive director, no matter what the board is?
I do.
And as the executive director or acting executive director, are you considered the keeper of the records?
Yes, I am.
And therefore, are you familiar with the complaint files and license files of auctioneers in the state?
I am.
Have you reviewed the license and complaint files of Tony Reed, who is doing business as MR Auction Company?
Yes, I have.
When was this complaint opened?
Fax was received in the board office in November of 2014, about the 28th, I believe.
And what was the reason it was opened?
It was opened by an individual that had found a business card and was reporting unlicensed activity.
A business card meaning a business card of the respondent?
M&R auctioneer and the respondent, Mr. Tony Reed.
Okay, and that's and who was the complainant in this matter?
The complainant in the matter was Albert Nichols. He filed with the board through fax and stated that he believed the individual had been doing auctions for between a year to 2 years.
Does Mr. Reed have an auctioneer license?
No, he does not.
How about M&R Auctions?
To the best of our knowledge and everything I could look for, they do not either.
Have either one of them ever applied for a license according to your records?
Not according to our records, no.
I'm going to ask you to identify a document if you would. Can you identify that document for me?
Yes, this is a new matter transmittal with this commission and all other boards. It is the way that a complaint is opened in the board office. And so on it, it lists who the complainant is, Mr. Albert Nichols, gives it the complaint number, and then the respondent is M&R Auction. This was opened on December 1st of 2014.
And included in this complaint, was there a copy of the business card in question that you just spoke of?
Yes, on page 4, it's the second to last page, is the business card that I mentioned. It says Reed's Auto and M&R Auction Company.
Your Honor, I ask that this be admitted as my exhibit number
Pardon
one.
me, exhibit number 1, entered into the record.
And ask that
Pass-
we be allowed to pass it out.
Pass that to the commission members, please.
Does the court wish me to give them an opportunity to review the complaint before I go further?
Go ahead, Ms. Ryan.
Thank you. What happens when someone files a complaint? That is, what is the complaint process?
The complaint process would be for the office to enter the data into our system. They would look for a license if one existed, because it's unlicensed activity. They would proceed to mail the documents to the individual for a response, or decide to do an investigation to determine what the case is, if they're in business, and so that is what was determined at this time by legal counsel.
Therefore, was an investigation pursued?
Yes, it was.
Okay, before we go into the investigation, what laws govern the licensing of auctioneers?
The licensing is under 62-19. 101 requires a license for everyone. 102 is the statute that also talks about advertising needing a license in order to.
And what does that
advertise.
statute say? Or what's the section of the statute that's relevant says?
Section 1 that is relevant says that the act to advertise or represent oneself as an auctioneer or the firm means that you must hold a license in order to do so.
Are there any exceptions to that law?
There are some exceptions under 103. Trustees, person performing these acts, as part of an investment property and selling your own items.
So you would not need a license to sell your own items?
That is correct.
So if Mr. Reed had been selling his own items without saying M&R Auction, would he have needed a license?
No, he would not have.
And what is the person who owns this company? What's his full name?
Mr. Tony Reed?
Mm-hmm.
That is correct.
Are there any other current complaints open against M&R Auction Company?
No, there are not.
How about Mr. Tony Reed?
There are no others at all.
Were there ever any other complaints against this respondent?
No.
So this is the only matter before this board.
The one and only, and the information we received is that he stopped shortly after this.
Do you know if he was made aware of the requirements for a license?
With the investigation, he was. When Mr. Ratcliffe reached out to him wanting to visit and look at records, then he was made aware that he would have needed a license.
And do you know what happened after he was made aware?
He immediately stopped functioning under M&R auctioneers and presenting himself to be doing auctions.
Now, as a part of your entire complaint file, do you have a copy of that investigation as well?
I do.
And who was the investigator in that matter?
The investigator was Rick Ratcliffe.
And who filed the written report?
The report would be filed by him.
Ask you to look at that again.
Marshall Buckner.
Thank you.
Thank you.
And when did Marshall Buckner go visit this respondent?
The date circled here is January of 2015.
Okay, after Mr. Radcliffe had called and told him to quit.
That is correct.
And what was the finding in that investigation?
The finding on this investigation, when I read it, was that, yes, he admitted to be selling things. He said that the items that he was selling were his own personal items, that he stopped immediately, and then proceeded to also accept the fact that he had been doing it for about a year.
Did he do an affidavit for Mr. Buckner?
I believe that he did.
Find that affidavit, I would ask you to read that into the record. May I approach, Your Honor? So I can-
Yes.
Mr. Reed, here it is. Yes. The affidavit is dated January of 7th of January 2015. It is signed by Mr. Reed. It states in the matter of M&R auction case number L14-AUC-RBS, and then the case number -2014-030411. I, Anthony R. Reed, state that I was conducting a business by the name of M&R Auction at 103 Lakewood Drive in Mooresburg, Tennessee. After operating for 1 year, I received a phone call from investigator Rick Ratcliffe advising me that a complaint was filed alleging unlicensed activity. After talking with Rick Ratcliffe, I told him I was unaware that I needed an auctioneer license to sell my own items. I told Mr. Ratcliffe that I would stop operating immediately. My conversation with Ratcliffe was on December 17th, 2014, and my business was closed by December 19th, 2014. And this affidavit is signed and notarized.
In that investigation, were there any copies of documents of any items that were sold?
No, there were not.
Any records of any items that were sold?
No, I believe he did not keep records of.
Okay. And did he indicate that it was he selling the items or M&R Auction selling the items?
He indicated that he was in the conversation.
And what does the business card show?
The business card reads, here we go. Reads Auto and M&R Auction Company, do not cease to pray. And then below it, it says Reverend Tony and Charlotte Reed, owners.
That's what it says. Does it say it does auctions?
No,
It just says auction company.
it does. It lists two different addresses. One would appear to be the business that the complaint's going to, and the other would possibly be personal, has phone numbers and a fax, and Facebook page.
Now, that advertisement says there's an auctioneer, is that correct?
That is correct.
And that is illegal under the auctioneer laws?
Yes, it is.
Your Honor, I would like to add this next document, which is the investigation report that is a part of the complaint file of Ms. Gamuccio's, entered as the next exhibit.
All right, that'll be fine. Exhibit number 2. Ryan will give the commissioners a moment to review this. All right, go ahead, Ms. Ryan.
Thank you. Do you know if Mr. Reed or M&R Auctions are still in business anywhere?
No, it's our understanding that he stopped doing business shortly after the call.
Do you know, or has he contacted you about anything at all?
Not at all.
Has he contacted the program at all that you know of?
Not that we are aware of, no.
Do you have any information about what assets he might have?
No, we sure don't.
Okay. Thank you, Your Honor. That is all I have for this.
All right, members of the commission, have any questions for this witness? No? Thank you, ma'am.
Your Honor,
Your
that
Honor.
concludes the state's proof.
All right. Do you have anything in closing you'd like to say, Ms. Ryan, while you're already at the podium?
Thank you. This particular matter, you have a respondent who was selling items. Whether he owned them or not, we don't know. But he was an individual, and he also had a business, M&R Auction. M&R Auction was the entity that was apparently selling the items. We do know that he quit upon a phone call to him because he stated he did not know the law. But of course, as you well know, ignorance of the law is no excuse. Having said that, it does appear that at least for a year he was doing some sort of business selling his items through the business. He also had a car that advertised the same. The state would assert that that is illegal and that he should have had a business at the time. Now, the problem we have in this particular matter is collection, and I will tell you that. Having said that, you are certainly, and you should, issue a civil penalty if you think it's appropriate. Whether we collect it or not is not the issue. But I will tell you that if indeed he is on Social Security disability, that income is protected from collection under the law. He has other assets, though, as far as we might know. So I'm asking today that you find that he be a violation of the law, issue an appropriate civil penalty, and that he pay all the court costs in this matter. Thank you.
Thank you, Ms. Ryan. Did you have a proposed order that you're going to submit to the board?
I
for
have
the-
proposed findings of facts.
Proposed findings of fact, yes, ma'am. Members of the commission, if I could have your attention for a brief moment before you review this document, then I'll give you an opportunity to review it. Make a few brief comments to you in the form of a charge. It's your responsibility at this time to make a decision in this matter. That decision will be the final order of this board. That decision must contain findings of fact, conclusions of law, a determination as to what, if any, penalty is appropriate in this matter should you determine that the respondent, Mr. Reed, has violated any provision of your Practice Act. And also, finally, to make a policy statement for the reason for the decision that you've reached. The burden of proof is on the state or the department, to prove by preponderance of the evidence or as the more probable conclusion that the factual allegations contained in the notice of charges are true. The burden of proof is also on the department to prove by that same preponderance of the evidence that the factual allegations that you find to be true constitute a violation of the statute and or rules that govern the practice of auctioneering in this state as is set forth in the notice of hearing. Should you determine by these findings of fact and conclusions of law that the respondent, Mr. Reed, has violated any provision of your Practice Act, you are authorized to impose discipline in this matter. Mr. Reed is not licensed by this commission, so you obviously cannot sanction his license. However, you do have the authority by law to issue a civil penalty in this matter, and you also are authorized by law to assess the costs of this proceeding if you believe that either of those sanctions are appropriate in this case. Your decision in this matter must be based only upon the record that was produced during the course of this hearing this morning. Miss Ryan has handed to you a document entitled Proposed Findings of Fact and Conclusions of Law. This sets forth the facts and the legal conclusions that the department, Ms. Ryan, believes have been established in this case. This document should not be considered as evidence in this case. This is merely the argument of counsel. However, you may wish to use those proposed findings as a guide during the course of your deliberations. If you look at the notice of hearing and charges in this matter, and you look at pages 2 and 3 of that document, it sets forth the statutes and rules that it has been alleged by the department that Mr. Reed is in violation of, and it also sets forth on page 3 of that document the statute and rule that authorizes the assessment of civil penalties and or costs of the proceeding should you find that that is appropriate. I'm sure that this commission is much more aware of their authority or the range of civil penalties that can be assessed than I am. However, I have a copy in your rules. It's 0160-1-.11 that sets forth the range of civil penalties, and we can discuss that in detail if you wish my assistance on that matter. Or you may be familiar with it, and we don't need to take up the time at this moment. Again, as the administrative judge, I will not participate in the decision that's made on the merits of the case. However, I will be available for any questions that you might have of me. And if you have no questions of me at this time, I will turn it over to the chair to conduct the deliberations.
Okay, I think the state's done a great job in presenting its case. This is fairly simple. I wish Mr. Reed had been here today to defend himself and to talk about it, but I do think that the finding of facts are as written, that the complaint was opened in approximately November of 2014, and it was opened up formally in around the 1st of December. An investigator was notified and was sent out to inspect and to find out what was going on with Mr. Reed's business based on the complaint that was filed. Mr. Tony Reed did, in fact, admit to conducting in business under his name, M&R Auction, and he said, even though he said he only sold property that he owned, but as soon as Mr. Reed, he admitted that he'd been operating that business for over a year, and while he was unlicensed, and admitted that he was unlicensed, and he effectively closed his business on December the 19th, 2014, after he was informed that he needed to have an auctioneer's license. He did advertise his business with his business card as Reed's Auto and M&R Auction, with the address listed where he was actively located in Rogersville, Tennessee, and Mooresburg, Tennessee. And he also advertised M&R's auction by means of a Facebook page. And since that time, he has not conducted any businesses, and I think the state has proved that, and those will be the finding of facts under this case. And I move that we accept those as written.
I would like to commend the council for doing a great job presenting the case. I know y'all have done extensive background work on this one. I agree. Did you make a motion? I second the motion. What about the penalty?
Start with finding of facts first.
Motion's been made to accept. Finding of facts and accept. Second's been made. All in favor, aye?
Aye.
Aye.
Mr. Chairman, are those the findings, and Mr. Morris, are those the findings of facts set forth in the proposed findings? Okay, thank you, sir.
Under the conclusions of law, Mr. Chairman, if you allow me, the respondent's acts and conduct as described in the foregoing allegations of fact constitute a violation of Tennessee Code Annotated 6219-102, which states in the relevant part, it is unlawful for any person to act or advertise or represent to be an auctioneer, apprentice auctioneer, or firm without holding a valid license issued by the commission under this chapter or prior state law. And then subsection 3, act or advertise or represent to be a public automobile auctioneer unless the person is duly licensed as a public automobile auctioneer and as a motor vehicle dealer under Title 55, Chapter 17, Part 1. Those would be the conclusions of law that he's in violation of as written. I move that we accept those.
Motion's been made to accept these. Second.
Motion been made to what?
Accept the
Conclusions of law.
conclusion of law.
Second.
Second. All in favor, aye?
Aye.
Aye.
As far as the determination of any civil penalty or fine or discipline, I think we're kind of open to whatever the board feels like. If anybody has a suggestion as to what that penalty should be, you might make.
Well, the objective of this board is to protect the public, and when we have auctioneers, when we have people running auctions without a license, without following the rules and regulations, this is when the public gets hurt. I move that we fine him $1,000 for each auction that he conducted.
How many would that be?
52, she said. We don't know how many.
You don't know how many he had.
Was it not? There was a date. That was the investigation started. Is that instead of the auction? Is that what that was?
Yes, Ms. Ryan, I'll let you respond if you can.
Thank you. We have no proof of any auctions taking place in particular. We just know he was in business for a year. According to his own statement, he was auctioning his old items for a year. Having said that, I can't tell you if it was 1, I can't tell you if it was 2, I can't tell you if it was 100.
I'll be talking to the mic.
No farm license, no public automobile auction license, no
Pull your mic down, Bob.
auctioneer's license. No farm license, no public automobile auction license, and no auctioneer's license.
Well, I'm confused that we don't know that he did an auction.
Members of the commission, let me just to perhaps if I can assist. I don't know if this will help you or not. The law that you found that he violated, 6219-102A1 states that if it's unlawful to act as or advertise or represent to be an auctioneer, etc., without holding a license, and 30 to act as or advertise or represent to be a public automobile auctioneer unless you're licensed. Your range of civil penalties is $0 to $1,000. So those are two different statutory provisions. The range of civil penalties is $0 to $1,000 for each of those two sections. Okay. Go ahead, Mr. Chairman.
So I'll agree. I mean, I think $1,000 per violation, I guess. What do you guys think?
So that's 2,000. Is that what you're saying?
That's what-
Did we not have anything in there for the firm? Because you got the public
He
auction and
he wasn't operating as a firm. He was
or a
operating
gallery or whatever. I mean,
no.
he had his MRR auction house.
Right.
So you had something, that entity should have been licensed, and then he should have been licensed, and then he should have had a public automobile auction license. He should have had 3 licenses.
So what do you think?
But I don't know if we can use the farm part or not, or gallery part too. I mean, is it all come under unlicensed activity?
The statute says for any person to. So I read this to mean, and Ms. Ryan, I read this to mean that this is in referencing to Mr. Reed.
Actually, Your Honor, the complaint was opened up against M&R Auction and Mr. Reed doing business as M&R Auction because it was not a corporation.
Okay, so it's one and the same.
One and the same.
It's one entity.
Sole proprietorship.
But he still would have had to have a farm or a gallery or something, wouldn't he?
Well, he had to do an auction.
Are we not at this point bound to the conclusions of law that we already agreed on, which is the 2?
Well, you can find other violations.
Okay.
Well, you're bound by the notice of charges. Okay, so you go back and look at the notice of charges and see what it is that he has been charged with. Okay, so you can't find him to have committed violations that he wasn't charged with.
Right.
All right.
Charged with unlicensed activity, I guess. That's the way it sounds to me.
When the complaint came in and the investigator went out, the investigator live drove to the auction place, right?
Go ahead, Ms. Ryan.
Well, I'm
No, go ahead.
I'm sorry, I was asking you a question.
The investigator went out
Sorry,
live
Judge.
and talked with him, and you have a copy of what he found. That's it. That's all we got.
But he admitted he was doing auctions.
Admitted he was selling his own items. That's correct.
At public auction. Did he have a sign up? We know.
You know what I know from the investigative report.
He had a card. They said he had a card.
Someone will come up with a figure. Motion.
Well, I move that we fine the defendant $1,000 for each offense on count 1 and count 2, and that we assess all the costs of this hearing in addition to that fine.
Motion's been made, $1,000 per occurrence and all court costs. So here's second.
What is, state that again, please.
It would be $1,000 for each count, which would be under A1 and A2 would be a total of $2,000 plus the cost of the proceedings against the defendant.
Is that 2 counts or just one?
There's 2 counts. It'd be $2,000.
What he says, 2,000 plus the cost of this hearing.
Right.
Is what Jeff made a motion of, Mr. Morris.
Well, and the mitigating part for me is the fact that he stopped immediately once he was notified.
Members of the commission, if I could interrupt for one moment, please. Well, 2 things. First of all, Ms. Ryan, this range is different than what I have.
I did print that from the auctioneer website. I don't know what date yours is, but that is what I printed yesterday from their site. I presume they're up to date. Are the rules up to date?
What I printed was off the Secretary of State's website on Friday. Wait a minute.
I cannot answer that question.
Oh, wait. Members of the commission, I apologize. Can we stand in recess for one moment and let me clarify something with Ms. Ryan?
Could we take 10 minutes?
Yes, absolutely. Take a break.
Okay, call the meeting back to order.
All right, members of the commission, apologize for the confusion. To clarify, we are correct on your range of civil penalties, 0 to 1,000. That is correct, and but I do think, for the record anyway, I would like to read this to you, and this is part of your rule, 0160-1-11-3. It says, in determining the amount of any penalty to be assessed pursuant to this rule, the commission may consider such factors as the following. A, whether the amount imposed will be a substantial economic deterrent to the violator. B, the circumstances leading to the violation. C, the severity of the violation and the risk of harm to the public. D, the economic benefits gained by the violator as a result of noncompliance. And E, the interests of the public. So I wanted to read that criteria into the record, and also to clarify that the range is $0 to $1,000 as we had previously discussed. With that statement, I'll turn it back over to the chairman.
Anybody else got anything to say?
I guess this is the time to say this, and I don't know. And this is interesting because 2 or 3 times I've heard either the witness or the counsel one say something about, he was selling his own stuff. And of course, you can sell your own stuff without a license, in my opinion. And I don't know if this is specifically covered in the law or not, but you can sell your own stuff without a license to a point. But if you're in the business of doing it and doing it on a regular basis, you got to have a license, in my opinion, regardless of whether you're selling your own stuff or somebody else's.
We have always been under the assumption, the commission has, that you could do a one-time sale, auction your stuff off. If you were selling your house and moving out, you could sell it, but then you couldn't go rent an apartment and decide you're going to have another auction. But that doesn't have a lot to do with this, I don't believe.
Hey, we've got a signed affidavit from this guy that he was doing what the state has proved. And we have a motion on the table to fine him $2,000 plus the cost of this hearing. Do I hear a second?
I second.
Motion's been made to fine him $2,000 plus court cost here today, and seconded. All in favor, aye?
Aye.
Aye.
And I think the next step would be the policy statement. And let me, if you don't mind, Mr. Chairman, as in all cases, it is the policy of this commission to act as oversight of all auction activities in the state of Tennessee and to provide protection of its citizens against any unlawful activities. Motion as the policy statement for this commission.
Motion's been made by Jeff on the policies. Second.
Second.
Second's been made. All in favor, aye?
Aye.
Aye.
Nothing further in this matter. We'll stand adjourned. Thank you, gentlemen. Thank you, Ms. Ryan.
Thank you.
He's the best judge.
Next time we have one, will you come back?
You're the best judge we have.
He is the best judge we've had.
Well,
Unfortunately, he isn't there full-time.
well, I'm retired and working half-time, but so you'll have to catch me on my work days.
You can come every.
Not on my golf days, right?
All right, pick back up our agenda. Mr.
Takes
Chairman.
us back to the director's report, is that right?
Thank you. We'll give everyone a minute to get cleared out. And thank you very much, Your Honor.
Hope I have another one soon.
Yes, on your iPads on page 11. We will continue.
Go ahead.
Thank you. This particular month, we've updated as of the end of May 31st. Our total budget is the $184,500. Total expenditures is $37,480.86. Revenue total is $199,720.24. The estimated cost backs, and again, those cost backs are not finalized. They include investigation costs. They include computerization of our new system. They include, at this point, the second line in the middle there under investigation and CSC. That's our customer service center that we have implemented. They have a new phone system that has been fantastic, new staff. That has a cost of $24,097.12. So the total estimate will be final by the next meeting that we have to include everything through the end of the fiscal year, which is June 30th. But those are the numbers for the board so far. And I hope to have final everything the next time that we meet, but everything seems to be in order. For this particular director's report, we don't have any legal updates. The legislative session ended and Nicole Avers was able to update the board on everything that went through. And so we'll be adding them every time that it impacts what the commission needs to look at. And so that is all that I have at this point for the director's report, and I will turn it over to legal counsel for the complaints.
Okay. Before I start with the legal report, we have one piece of business to take care of. Regina, will you pass those out to them? I believe Julie had started rulemaking with you a couple years ago, and we talked about the definitions a few months ago, I guess. There were two questions, number 4 and number 6, that were not answered in accordance with the AG, so I redrafted those. I just need you to take a quick look at them and approve them. They don't change anything, they're just...
This is the same thing we've seen before.
It's exactly the same thing, except number 4 and number 6, I had to change the answers to appease the AG.
I'll make a motion, we approve.
Motion's been made to approve here. Second.
Second.
Second, all in favor, aye?
Aye.
Okay, ready for the legal report?
Go ahead.
Number 1, 2016014591. This complaint was filed anonymously by an alleged unlicensed activity.
What page are we on?
Page 13.
13.
Sorry. That was the legal report from May. That was on the minutes.
Where I'm at.
All right, go ahead.
Okay. Upon receipt of this complaint, council reviewed respondent's webpage, which states that respondent offers full-service estate liquidations and appraisals. Respondent's company is focused on high-end estates with period antique furniture, fine and decorative arts, currency, coins, firearms, gems, and jewelry. Respondent's webpage explains that respondent performs all aspects in conducting a liquidation of estate contents. After an initial appointment, the actual sale is scheduled for 2 to 3 days over a weekend. Complainant submitted a webpage from estatesales.net for an estate sale that the respondent was performing. The webpage stated that for this particular estate sale, bid sheets were available at the estate sale. Respondent stated the respondent is not an auction company, does not have an auctioneer license, nor has the respondent ever represented to be an auctioneer. Respondent states that the bid sheets allow customers to make offers on tag sale items that they do not want to pay full asking price. Respondent states that they call them bid sheets, but they should probably change the name to offer sheets in order to avoid confusion. Council's recommendation is that this matter be dismissed.
I read over this case, prior to, with the email, that this kind of opens a can of worms. If they're able to make competing offers against one another, whether it be in writing, orally, or however they do it, if they're using one offer to say, well, now you got to be, it's $100, now you got to be $125. There's nothing different about that than having an auction. And so if they want to say the price is this, and they can sell it for that or negotiate one-on-one with them to get the price they want to, that's one thing. But if they're using competing offers, if everybody's allowed to fill out an offer for that desk or that table or that piece of art, then to me that's having an auction. So I would really like to know how they're conducting their business and whether they really are conducting a silent auction, for items that they're selling. So there's really not enough in this for us to say yes or no, but I would tell you that it sounds, like they say, if it looks like an auction, smells like an auction, it's probably an auction, So I don't know.
I agree. This didn't just happen yesterday. This wasn't their first rodeo that they did. So in my opinion, they've been conducting auctions on items since they've been in business, if they went so far as to have a bid sheet. And on this particular one, I disagree with council's recommendation.
I don't know where to go with it. That's
We can do a letter of instruction and explain to them what they need to be doing. They need to be licensed if they're going to let people make offers.
I think they should be explained the definition of an auction.
Know the definition of an auction.
I'm sure they're real familiar with it because they've been conducting one. But I agree with Jeff. I don't know what we can do at this time, but it needs to cease and desist giving out bid sheets. That's what we do, and that's why we have a license and all the rules and regulations to go by.
You want to make that in the form of a motion, Howard?
Yes.
Second that.
Motion's been made to, say it again.
Send them a letter of instruction.
Send them a letter of instruction. Been seconded by Jeff. All in favor, aye?
Aye.
Aye. Number 2.
Number 2, 2016022741. This complaint was filed anonymously and alleged that no firm license was listed on an advertisement. Complainant submitted an advertisement for an upcoming auction, and no firm license number was listed on the advertisement. Respondent stated it sent an auction flyer to a local newspaper to be placed as an advertisement in the newspaper. The flyer included the firm license number. Additionally, the respondent submitted an email from the advertising manager at the newspaper which stated that when the artwork was received from the respondent, it did have the firm license number on it, but when the newspaper advertisement was resized, the firm license number got left off and it was printed without the firm license number. Council recommends this matter be dismissed.
I make a motion, we accept council's recommendation and dismiss.
Motion's been made to dismiss. Second.
Second.
Second made. All in favor, aye?
Aye.
Aye. 3.
Number 3, 2016022761 and 2016022762. This complaint was filed anonymously alleging a violation of TCA 35-5-112. Complainant submitted 3 newspaper advertisements and circled the buyer's premium amount listed on all 3 advertisements. The following information was received. February 20th, 2016, auction advertisement stated the buyer's premium to be charged was 8%. February 27th, 2016, auction advertisement stated the buyer's premium to be charged was 10%. March 5th, 2016, auction advertisement did not state the amount of the buyer's premium to be charged. I've included there what TCA 35-5112 states. In response, the respondent forwarded the order and decrees confirming sale of property for each auction listed in the advertisements. February 20th, 2016, the auctioneer's fee to be paid to respondent as ordered by the court was set at 8%. February 27th, 2016, the chancellor approved the court sale to be conducted with a 10% buyer's premium, and the notice of sale conformed to the order of the court. Upon confirmation of the sale, the chancellor ordered the auction's fee paid to the respondent be 8%. The March 5th, 2016 auctioneer's fee to be paid to respondent as ordered by the court was set at 8%. Respondent states that the complaint was based upon the information contained in the notice of court sale advertised by the clerk and master. When a sale is ordered by the chancellor, the clerk and master is appointed as special commission to take possession of the property and conduct the sale. These duties include publishing the required notice. The auctioneer is ordered to assist the clerk and master in its duties as a subordinate, subject to the clerk and master's order. So, reasoning and recommendation. Although the advertisement for the February 2016 auction states a buyer's premium of 10% will be charged to the buyer, the decree confirming sale from the chancellor states that the respondent will receive 8% commission. As such, council recommends this matter be dismissed.
I move that we accept the recommendation of council and dismiss this case.
Jeff's made a motion to accept the council recommendation. Do I hear a second?
Was there one advertisement that there was no buyer's premium advertised?
There was, but I believe at the auction it stated that it was 10%. And on the order,
But in the newspaper, didn't state any buyer's premium.
that is what it said in the complaint, I believe.
All right, did it say, it said it was gonna charge one, it just didn't say how much, or it?
The
They didn't
real
say
issue
nothing
that
about
the
it.
complainant was noting is that it said for the 27th auction, they were gonna charge 10%. And they cited the rule, the TCA 35, where it said 8%, and they were saying it was 10%, not 8%. But actually in the order, I read the judge's order, and it said that the auctioneer was only gonna get 8%.
All right, but then the other one on March 5th says auction advertisement did not state the amount of the buyer's premium. So it said it's gonna have one, it just didn't say how much.
Correct.
Okay. What does our law say about that? Do we have to advertise the amount, or can we just say we're gonna charge one?
The law says you have to advertise the amount. Correct?
Give me a minute.
It's right here.
It should, but I don't know what it does.
I don't know if it does or not, Howard.
I thought I just read that a second ago.
A buyer's premium applied, because I've seen that before too.
It says an auctioneer, auction firm, or gallery shall disclose the existence and amount of any buyer's premium commission or fee to be charged to buyers at an auction sale. Such disclosure shall be made in all advertising and orally announced immediately prior to the start of the auction. So you're right. The amount should be on there. Yep, that was my oversight.
Well, I second Jeff's motion. I just wanted to bring that point out that it has to list the amount.
It might not hurt to send them a letter of instruction or something,
Just a letter of instruction with the buyer's premium advertising.
and
Do you want to change your motion?
Yeah, we'll just change it to accept the dismissal, but to send them a letter of instruction as to that he must advertise the amount and of the buyer's premium in all advertising.
I'll second that.
Motion's been made to dismiss, send a letter, seconded by Howard. All in favor, aye? Aye.
Okay, number 4, 2016029201. This complaint was filed anonymously for unlicensed activity. Complainant alleged that while watching television, the respondent ran an auction advertisement. Respondent stated that the respondent's real estate company runs 3 30-second commercials every Sunday during a sports show on television. Respondent states that none of the commercials have any auction content and are just promoting the respondent's career as a leading realtor. Respondent states that this complaint pertains to a 10 to 15 second mention in by the host. Respondent's office sends the host and producer an email every week prior to the telecast. Respondent submitted the email that was sent to the producer that week, which stated who the auction company and auctioneer for the farm sale. It was not the respondent or his real estate company. Also submitted was the brochure for the auction, which was advertised in the name and license number of the auctioneer and stated in conjunction with the respondent. Council recommends this matter be dismissed.
So your findings were that while he just has a real estate company, he did say that he's selling in conjunction with this
It
auction
said
company?
in conjunction with, and it said the auctioneer's name and his company and
Okay.
his license number.
Okay.
But he did say, he did advertise on TV an auction without an auctioneer's license, without being an auctioneer.
My argument would be that he said he was a realtor in conjunction with such and such auctioneer
Did
who is selling this property or this.
Did he announce the firm license of the auctioneer or the auctioneer's company name or the auctioneer's number?
According to what was sent to the producer, it was the auctioneer's name and his license number, and that was to be mentioned. I did not hear the actual telecast.
Could you get a copy of the actual telecast?
I could try.
I make a motion that we get a copy of the actual telecast.
Second.
Motion been made to get a copy of the telecast by Howard, seconded by Bobby. All in favor, aye.
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 Okay. That means we're gonna delay the.
So it'll essentially stay open until it'll be
Yeah.
represented next
Right,
month.
represented, right, okay.
So did you guys agree or not?
Yeah.
Okay, everybody agree?
Yeah.
Okay.
Okay, number 5 is a really long one, and I don't know if you want me to read 2 pages to you or you prefer to look
To hear
through.
you
Is
read.
there a way that I've tried reading this thing
Yeah,
before? and
This one
I
is
read a
very
little-
I
complicated.
know,
bit
if you
of
could, if you could not read it, but summarize
Try to summarize
for
it because I've talked to some of these complainants on the phone, so it might help. So this one, I'll just put the number in. It's 2016029181. And so from what I understand, what happened is that they all went to this auction and they were told, you know, we're going to sell lot by lot and then there'll be a regrouping. And so they went lot by lot 1 through 12. And then they went back and said, does anybody want to regroup and rebid? And some regrouping occurred. What I heard from the complainants was that at that point they thought they had purchased the property and then went on to sit.
As you go along, I'm gonna ask you a question. Did he ever cry sold?
I asked that question and no one can tell me the answer.
Okay.
And so essentially the auctioneer went on to sell some other farm property, farm equipment, etc., and then came back and apparently opened it one more time to sell the property in its entirety, and someone purchased it, they think.
Okay. But that was, so they did the real estate first, did the individual lots, grouped them back together, any groupings that they wanted. Then they went on and sold all the personal property.
Personal property and farm equipment.
For an hour and a half.
Yep.
And then they came back and told the crowd, well, we've got a late bidder and now he's going to buy the whole thing.
Yeah, I talked to multiple people
This happened when? In May?
in May.
Did it close?
I don't know the status of that property. I assume it closed with the purchaser of the entire.
Are the complaints are from the individuals who thought that they purchased the property?
Some of them thought they purchased the property. Some of them were just in attendance at the
There
auction.
was 5 different people there that filed a complaint.
Yeah, I actually believe, yeah, there are 5 separate people that,
So obviously, a lot of people there felt like there was something going on.
yeah,
Okay.
Was there a recording of the auction?
that I do not know.
That we need to know. Because if he said sold, you can't suck it back in and
Right.
not sell it. And I've never, I'm not saying it wouldn't happen, but I've never been to a real estate sale where you sold it and an hour and a half later you come back and resold it again.
I agree, that was my issue with it.
Oh, yeah, mine too.
I think
know,
we
I
need to
did
find
one-
out if it was recorded.
I did one of them multiple parcel things with Marvin one time. We had 3 checks, took us 3 hours, had to sell. Time they got done swapping around,
Yeah.
carrying on, it was,
I mean, they can
And I
take a
mean-
while, and I understand that, but they don't go off and you stop that auction. You know, if he said, look, we're gonna post those bids and put this on hold because it didn't reach a reserve or what have you, he should have made that announcement. If he cried sold and then came back and this guy came in an hour and a half later and bought it, then he's in violation.
Right. No,
There's-
and that was my issue. I
there's-
reached out and asked people, and they said they couldn't recall if he said sold or,
There's 2 questions I'd like to know. Does he have a recording? Did the property close?
And to whom?
And to whom?
you know, and it sounds like too, I don't know, it's, like I said, it's even hard to read. But it sounded like the buyers might have been trying to get together too. Cause one of them had done cut a deal to sell the house to somebody when he ain't even closed yet, so they might have been trying to get together on them too, you just don't know.
well, and that, I actually talked to that person, and he purchased the property, he had the high bid on the lot with the home on it. And then someone came in and regrouped 3 lots, and it included that, and he lost the high bid. But then he went and talked to the person that he thought purchased it, and they cut a deal for him to buy the home from that person.
Well, there's nothing wrong with that.
No, yeah, and so that's why,
There's
in my
nothing wrong with
mind,
it on one hand. On the other hand, if it might have made the sellers more money if he'd have rebid it
Well,
rather than
well,
trying to
you-
buy it straight from him. I mean, sometimes
He
we
couldn't rebid it. He bid the house in, and then they sold 2 more lots, and somebody put these 3 lots together, which they had to do to put the man that bought the house out. So he's sitting here wanting the house, and he's out, and the man that bought the other 2 lots has the right to tell him when this thing, he's got to close it out. But once it closes out, I'll sell you the house.
Did he say that, or did he say, "Well, don't you bid against me, and I'll go
Wasn't
buy this"? I mean, we don't know. You know, I mean, I've had people get together on me like that. I mean, sometimes we forget that the sellers are general public too. I mean, you got to get them as much money as you can. I don't know, but I would like to know if there's a recording.
okay, so we'll leave this one open, look for a recording, see if it closed, and to whom. We can do that.
And if there was a handbill.
Yeah, I wouldn't. I'd like to see some of the advertising. It wouldn't hurt.
And also, was it an absolute auction?
The advertisements did indicate that it was an absolute auction.
Was?
Yep.
Yeah, more important, well, we need to get the recording if we can get it.
Every time I've been to one done it, end up selling that, and we done with Marvin, end up selling the way I sold it in the first place. Except it took 3 hours.
Okay, we ready for number 6?
Let's go.
Can we do the same thing here instead of reading it, just kind of tell us what you think happened?
Yeah. So the respondents, it's 2016-030371 and 2016-030372. So this is what I understand for this one, is that it was apparently a rainy day, and there were about 9 bidders in attendance at the auction. Some people were in their car, some people were across the street under an awning, some people were near the truck, and the auctioneer had trouble getting a bid, and when he got some bids, he started walking around to the people in attendance, and he ended up, according to the complainant, buy this truck that had 3 men in it. And when the complainant would bid, he would come up with a higher bid. And so,
Was this a reserve or an absolute auction?
this one, I don't know that I know that one on, I don't think those facts were presented. I'd have to
That's
dig through it.
critical in this case. Because if he was bidding on behalf of the seller against the reserve, then that's one thing. If he was just taking bids out of the air, then
According to the auctioneer in this case, he had absentee bids.
prove that up, right?
And so, I guess at one point, the complainant who was bidding on the property walked away because he was frustrated. And one of the ringmen went over and said, come back and bid one more time and you'll get it. Which is the only thing that I thought either there was a reserve or an absentee bidder, because the auctioneer claims to have an absentee bid for $50,000. And that's where the ringman stated, if you come back and bid one more time, you'll get it. So I do know that I guess the complainant did purchase the property at $50,000 and then went back and said he didn't want it. And so there was no contract at that point between, I mean, he lost his earnest money and walked away from it.
We're talking about real estate here, right?
Yes.
Okay. So did the respondent provide you a copy of the listing agreement for the real estate?
The respondent did not, he just provided me with this statement that I have in here.
I would think that we would need to know what, whether it was a reserve auction or an absolute auction. And if he had absentee bids, in what form did he have absentee bids? This kind of activity by auctioneers is what gives auctioneering a bad name, because everybody's suspect of auctioneers anyway, and when you start grabbing bids out of a truck of 3 men that never made a bid, you got a problem. So I think we need some more information on this case.
Okay, so we're gonna find out what kind of auction it was and in what forms of bids did he have the absentee, and see if he can provide.
Was it absolute? Was it reserve? What was the reserve if it was? If he had absentee bids, in what form did he have absentee bids? Were they in writing or orally, or were they people that were there, or did they fill out a form and agree to pay? If they, I mean, were they registered bidders? Were they not registered bidders?
Copy of the sales agreement.
This one smells real bad.
Yeah, I didn't really care for this one.
Yeah.
All right, so the guy wrote the earnest money check and signed the contract,
Yep.
Who,
and then decided he didn't want it.
Yep.
Felt like he was hoodwinked, though. I
he
can tell.
decided he wouldn't take it because
Decided because he
been
smelled a rat.
screwed, yeah.
Yeah. Yeah, I'd like to see the listing contract, the advertising.
Is this a long way from Nashville where this sale?
Kind of like Jeff. This is.
Is it,
This one I'm not sure on where this one.
if it wasn't too far for him to drive, it'd be nice if he'd come down. The complaint.
I'll try to get all the information I can from him. That way we can keep it anonymous at this point.
Yeah, and I'd like to see, you know, the contract between the buyer and the seller and the. Huh.
Next one.
7.
Okay, number 7. Respondent 1, 2016039521. Respondent 2, 2016039522. And Respondent 3 is 2016039523. This complaint was filed by a consumer and alleged that a fraudulent auction was to be held on July 16, 2016. Complainant alleged that there was no signature by the actual owner of the property, but instead the actual owner was misled by her stepson. Complainant states that the owner's stepson told the owner that a liquidator was going to buy and remove all of the surplus property from the business, which included light fixtures and other lighting inventory. Additionally, complainant states that some of his personal property and vehicles were stored at the property and that he did not sell these items to the respondents. Complainant states the sale of inventory was never signed by the legal owner of the business. The complaint was not sent out for response, but instead sent to investigations. Our investigator stated the following: the stepson is the vice president of the business that was liquidated. The actual owner that the complainant refers to is the secretary of the business. Respondent and stepson provided documentation that the business sold off a majority of its surplus inventory to respondents 1, 2, and 3 on April 27, 2016, and that these items were being sold at auction on July 16, 2016. The stepson told the investigator that this was a business decision made by the vice president, which is the stepson, and the secretary, which is his mom and the actual owner of the property. And the complainant has no authority in regards to the business, and that this was the complainant's way to retaliate against the family. The stepson provided a statement to our investigator that he has the legal authority to sign contracts on behalf of the business. No estate items were included in the auction, only materials acquired and owned by the company, and all of the complainant's personal items were excluded from the auction. The investigator was also provided a copy of the contract between the vice president and respondents 1 and 3, and all items that were sold on July 16, 2016 were the legal property of respondents 1 and 3 to sell. My recommendation is that this matter be dismissed.
So the complainant was the mother?
The complainant was, I believe, a brother that had nothing to do with the business.
Okay.
And the president of the business. Okay, the president of the business was deceased. I believe he was the father, and he was deceased. And
So the brother of the stepson filed the complaint. And what was his jurisdiction in filing the complaint? Was he an owner of any of the property
No.
at all?
he stated that he had personal property on the property, which we were told was excluded from the auction.
None of his stuff was sold.
No, and we sent an investigator out immediately.
So what was the
same
basis
day.
of his complaint?
That he thought that the actual owner was misled.
His mother.
And I don't know if it's his mother or just the mom is what.
Okay.
This one's a very confusing matter too, and our investigator went out immediately on.
Was the complainant damaged in any way?
No.
Was there anything illegally going on in this case?
No. I reviewed the contract and it was all.
Well, then I move we dismiss the case.
Second.
Been made to dismiss, second. All in favor, aye?
Aye.
Aye.
Okay, number 8. Respondent 1, 2016-036341. Respondent 2, 2016-036342. And Respondent 3 is 2016-036-343. This complaint was filed by a competitor and alleged that the gallery owner is only present at about half of the auctions that are conducted at the gallery. Complainant alleges that Respondent 1 is an auction gallery and Respondent 2, gallery owner, is only present at about half the auctions due to other obligations and is required to be present at all auction activities. Complainant alleges that Respondent 2 holds auctions about every other week without Respondent 2 present, which is in violation of the law. Complainant states that this has been brought to Respondent 2's attention but has been ignored. Complainant alleges that Respondent 3 is currently conducting the auctions and that it is the auctioneer's responsibility to ensure the auction is legal. Additionally, complainant alleges that on a regular basis, ghost bidders are used to run up the bids on attendees. Although not illegal, it shows ethical issues at the gallery. In response, Respondent 2 stated that she is present at the gallery for all auctions but leaves during some of the auctions in order to go to her second job. Respondent 2 states that there is a licensed auctioneer present at all auctions for the duration of the auction. And additionally, Respondent 2 was not aware of any ghost bidding at the gallery. Council recommends that this matter be dismissed.
Based on what's the story? I mean,
From what I know, this complainant used to be an auctioneer at this gallery, and he believes that the gallery owner, which this is not in our rules or laws, has to be present at all
I
auctions.
think she does.
And she does not, according to our
No.
statute.
So long as a licensed auctioneer is running the auction under her gallery license, I think it's completely legal.
Yeah.
You could have a gallery license and hire Mr. Morris to be your auctioneer, and you'd never show up so long as you run it, as long as he has a license and conducts it according to the law. I second, or do you make a mo-
I will move that we dismiss the case, yes.
Motion's been made, dismiss, and seconded. All in favor, aye?
Aye.
Aye.
Perfect. That is the legal report. I will look into those. I believe we had 3 open complaints, and I will get some further information for you all on those.
All right. New business will be next, if we have any.
What page is that?
Page 1.
Oh, okay. Bobby has something.
What's up, Bob?
Sir, was it you that had asked us, I can't remember, if we had any recommendations or anything we'd like to look at about as far as laws and things like that, changing laws and...
We did, and I mean, they've already presented everything to the legislature, so I don't know if we would be able to get in still, or if we would have to. Rules we can always change if you have a rule changes.
Well, there's an old law, and I meant to email it to you and I forgot it, and I'll find the number of it. I can't remember what the TCA number is or whatever, but it says that you can only have a court-ordered auction on Saturday between the hours of 10 to 2 or something like that. And it's back from whenever they figured a man had to be able to drive his wagon of horses so far to get to somewhere to have a sale. It's way out of date.
Is that in our?
No, it's
Our
not in our
it's in
law.
chapter 30.
I'm not sure where, it's not in our law.
It might be chapter 35 under the judicial.
It may be.
Okay.
But it's something that's ridiculous that nowadays needs to be changed. I mean, we do sales during the week and 6 o'clock in the evening, and you know the one I'm talking about. It's just out of date.
I was wanting to ask too about, I think the last time I was here, we talked about trying to do something with a tag sale. People doing the tag estate sales.
We had one today.
Well, I know what's the status, what did we do on that? What did we,
Oh, yeah. I've got something else I want to talk about too. Get a chance.
if, I was just wondering what we did on that, or if we decided to try to get something done to where they had to have a license to do what they're doing.
I don't know if you talked about that with me, or was it maybe Keeling?
I think it was, but I think what we decided to do, that we were going to see if we could get together before the legislature meets next time and get somebody to sponsor a bill. And I've been working on that a little bit, and I was
Okay.
gonna get Jeff to help me if he will.
Okay, Jeff,
Glad to.
you got something you said?
Yeah, this thing that came out in our newsletter about under the judicial and trust sales, it was a shock to me that now we have to do all real estate property auctions at the property. I mean, how did that slip in
I'd
there?
like to know where that came from too.
That's just
We
that
didn't even
in a
know
lot of
nothing
cases
about
you
that.
can't do that. I don't know how we get our foot in the door to talk about that, but
Me to look into that one, where it came from.
yeah, I
who-
mean,
I'd like to know
Who
where it
pushed
came
it?
from.
you know, and then they limit what we can charge, and you know, we
Is that a court, are you saying that's a court sale?
It's a judicial sale.
Okay, we are doing 85 pieces of property for the city of, for the county of Knoxville. Okay, it's tax sales. There is no way under God's creation that you could go to 85 properties and have an auction, because some of them you'd probably get shot if you pulled in the driveway.
Right.
That can't be a law. Can't be.
What was the?
If this is TCA 355112.
It was in the newsletter.
B.
Yeah, but
It says
whoever wrote the
whenever
news.
real property is sold at public auction or at a public sale conducted by an auctioneer, the sale shall be conducted on the real property to be sold. I mean, that's a disastrous law for a lot of us.
I'm probably gonna get fined next week, but.
I mean, I don't know how we bring that, I mean, I don't know who, somebody wrote that doesn't know anything about doing auctions, I can tell you that. A lot of these tax sales
Know
or
about that?
judicial sales you're selling tracts of property that are landlocked or down in creek beds and, side of mountains and all this kind of stuff, and there's no way to be at the property.
An island on the river?
Yeah, same thing. Or a shotgun house in South Memphis, I'll tell you what, I ain't going down there.
What is the penalty for doing it?
I don't know, but I mean, it's just,
I'm gonna get ready to pay my fine.
$1,000.
I'm like you, Howard, I'll be fined a bunch.
I'll look into that and see.
I'd rather them sit in my big room in my office and have it on a screen and everybody have a nice, comfortable Coca-Cola in their hand
I'll see if I can figure out where that came from
while they're
and
bidding.
get some stuff together for you guys.
Yeah, I mean, that's a bad law right there. And
Anything
I'd like
else?
to go on record. I think
Russell?
There's a mic right there. Yeah, you go.
Morning, Ressa Hansen with Nashville Auction School. We apologize, we were a little bit late this morning. I had submitted a request to be on the agenda, and I think we were on the agenda.
And you were approved.
We were?
Yeah, you
That's all
got
been
approved.
taken care
Yeah,
of? Okay, so I don't need to speak to it, and I
Nope.
appreciate it, and thank y'all very much.
Anything else? All hearts and minds clear?
I think we are good. We've got nothing else for the board. We'll do some follow-up for the next meeting. Make sure to get you everything to your emails timely and in advance. If you need anything in the meantime, call anyone in the board office. They'll know how to reach me, and we'll definitely send you everything else in advance. I think that's all we have.
Well, I'd like to say one thing. Then you mentioned a sore spot with me. Call anyone in the office. How do you do that?
Howard, I'll give you my number.
I've got business cards here. I'm going to hand you mine because that way they can reach me. But you're right.
Hey, Ressa.
Well, we did get
Y'all need
we
to
got
do
the
it.
one phone number fixed that was going to that accountant's
Yes.
desk. We got that
Yes.
figured out, so that did get fixed, Howard.
Yes.
My wife tried. That brings up another subject too that I had on my mind.
Y'all need to do a seminar on how to renew your license now, too. That's a nightmare. Takes more than a newsletter.
Well, I will give you a quick update on the renewals. There is a video now that they put out. I wish we'd done it proactively, not after many months of renewing online. It has been very helpful because the registration process the first time is cumbersome, to say the least. So we feel your pain, but I appreciate if you
I've got like 3
got
guys
through.
in my office that don't do computers, and I've had
Yeah.
to go in there and set them up, and they're not even due now. And I said, we better let's go and set it up now, because it
Yeah.
took me about 3 weeks to figure mine out.
It's it is the setting up. The next time's supposed to be smoother, but I appreciate it. The Zendesk system for the customer service, it picks up a lot of our calls, but we have 2 staff at the office that rotate the calls as well. So as the volume's high, they'll pick up as well. But I'll make sure you've got my number. If there's anything you ever need, you can always reach me, and if I'm not available, Cody or Dennis will help out.
Well, it has been some kind of nightmare to get a hold of someone in the Tennessee Auctioneer Commission office.
I'm
So
sorry to hear that.
you're on temporary assignment, or is this?
That is correct.
And then what should we expect for as a permanent assignment?
I imagine that the assistant commissioner and the deputy commissioner will decide in the next week or two what they're going to do with the centralized boards, and this would be one of the commissions on it.
We don't know who's going to be the executive director at this point. do we?
No, but you're going to each leave hopefully with my card. I think I brought enough, and if not, I'll get them for you.
Okay.
You'll reach me with anything at all that comes
I
up.
recommend you, so don't worry about it.
Thank you.
All right. Any
We'll need a motion to adjourn us.
motion?
I move with adjourn.
Motion been made to adjourn. All in favor, say aye. Second. All in favor, aye.
Aye.
We're adjourned.
Thank you very much.